Welcome to Classroom 2 Courtroom. Here's your host, Scott Benton.
Hey everyone, Scott Benton here. How are you? I am the host of the Classroom to Courtroom podcast, where we help you easily transition from law school student in law school into your professional career after you pass the bar as an attorney, and where we make the practice of law fun. And today we're going to answer the question of, why should I dig 3 levels down? Why should I dig 3 levels down? Why should I bother? Are you a law student or recent graduate waiting for admission to the California bar and eager to gain real-world legal experience? Join the Legacy Lawyers' coveted associate programs in sunny Southern California. Our hands-on spring, summer, and fall programs provide opportunities to dive into high-stakes probate litigation. If you aspire to litigate and thrive in an America First culture that values God, family, and country, we want you on our team. Don't wait, space is limited. Call 714-766-0457 to learn more about this exciting opportunity. That's 714-766-0457. Elevate your legal career with the Legacy Lawyers. Okay, what are we even talking about here? Let's set the stage before we try and get into that question. Now, first of all, since I work for a trust and probate law firm, we're going to put this fictionalized scenario together that takes place in a trust and probate law firm, because that's what I know, working in a trust and probate law firm. But it's still going to apply to any law firm that works with clients. And then second, for context, we're going to establish that we're talking about gathering case facts. So if you've been an ardent listener of the Classroom to Courtroom podcast, you probably already know that we've talked about gathering case facts on several podcast episodes. We're probably going to talk about them a lot in future podcast episodes. And if you're not an ardent listener, what are you waiting for? Come on, I mean, we're teaching you everything you need to know to practice law as an attorney, which is a subject that is not taught in law school. It's why we're here. It's why the Courtroom Classroom podcast even exists. It's here because this stuff is priceless, so take advantage of it. In our fictionalized scenario, we have a client in a trust and probate law firm that's meeting with an attorney. Now, the attorney is now working for the client to help the client achieve their legal objectives. Now, here the prospect, they'd called in for the first time. They spoke to an intake department. That's usually what happens. And the intake department, that person was taking down all the basic information about this case that the potential client or the prospect called up about. And the intake person determined that this looked like a pretty good case that was going to be viable. And so they set up an appointment with the prospect, the potential new client, with an attorney. And on that day, the attorney met with that potential client, and this is their initial consultation now. So the attorney is going to ask much more probing questions. The potential client is not the client. They haven't hired the firm or the attorney yet. The attorney in this initial consultation, those are usually short, maybe a half an hour, sometimes longer, depending on the complexity. But the attorney is going to ask more complex questions, or they're going to go a little deeper. They're still at the first level, but the attorney is still trying to determine if this is a viable case. And let's say in this fictionalized example that, of course, this is definitely a case that we can help you with. The prospect agrees with the attorney, and the attorney is hired, the firm is hired to represent the client. Now, the client, they've signed the CSA, that's the client services agreement, and they take out their credit card. They make their initial trust account deposit, and now they are an official client of that law firm. And now the attorney is officially representing that client. The attorney is going to sit down and they're going to come up with a list of follow-up questions. Now, in their next meeting, the attorney is going to begin asking probably a long series of open-ended questions. And what the attorney is doing is they're mining the client for absolutely as much information as they possibly can to produce case facts until the client, they simply get to a point where they literally have nothing more to say. They've said everything and probably 3 times, where there's just nothing more to contribute. There are no new ideas. So now that we understand where the case is at this point in the process, we can really better understand the idea that we're talking about, which is digging 3 levels down. Now, in this example, where the attorney is now meeting with the client for a deep dive exploration into the client's story, this is the point in time where they're going to start to go down into those 3 levels and get that deep into the case. But yeah, and you're going to ask the question, but why? Why? What's the point? Why go 3 levels deep? Really? Do we need to go this deep into a case? Aren't the case facts they've already gotten on all of these other meetings enough? There's really a few good reasons why. So let's start with the first. The first reason is that you're going to need as many case facts as possible. And one way to do that is to ask as many questions as you can until, like we've seen, the client has no more to contribute. And what happens at that point is that they've completely emptied out their brain. There's just empty space in their brain. So you're going to have a number of just valuable case facts that came out from that, of just purging out all just years sometimes of information they've held in their brains. And you also have all the intake notes. You have those case facts and the notes from your initial consultation. But you're not even done at that point. You are now going one more layer down. So the way that you do that at this point, so we're going from layer 1 to layer 2, is you're simply going to wait, because the client, they've exhausted themselves. Now, the way you do that is to simply wait. You're waiting for new facts to come in from your client. And now the reason is their mind is emptied from telling you all of the case facts in the first place. And that provides an opportunity now for more facts to come in and fill that empty brain space. There's new connections that are going to be made. What happens is they've carried around for quite a long time all those initial case facts. And when you have all those initial case facts just cluttering your brain, you can't get to the case facts behind the case facts. So that's what you're trying to do. You're trying to get to the case facts behind the case facts. But to do that, you got to empty your mind and get to those new facts that now come flooding back in. And that's when you're going to find that there are a few golden nuggets that are going to help you frame the story of your case. Not only that, it's going to help you form your argument, and it's going to help you decide on evidence that you're going to want to put in front of a judge. So it's going to help you decide on things like expert witnesses that you're going to want to engage, and it's going to help you decide on the witness declarations that you're going to want to pursue and seek out and get. By the way, so we're at level 2. This might be enough at this point for you to really decide that you have what you need, but you really should try to go for that 3rd level. And this is going to be the hardest level to get to. And there may not be anything there, but it's still worth checking into that 3rd level just to see if there's anything more there, because a lot of times there's value that you couldn't possibly expect. So you want to just really, again, get down into that 3rd level. How do you do that? To do that, you're going to want to ask open-ended questions. And sometimes your client they're going to already have the case facts and all of those case facts and the facts behind the case facts, but they may not themselves have gone to the 3rd level. They haven't gone 3 levels deep. So that's your opportunity to start asking questions that are, again, open-ended, such as, and then what happened? Or maybe something like, you know what these are. You can say, what did they say? Or, okay, what did they do after you told them that? You can say things like that. You can say things like, okay, tell me more about that day you were out on the boat, or who was at the party, that time at that party when you were told that you were getting half of the entire estate by your father? Who was there? These are open-ended questions. So reaching that critical 3rd level down, it's going to give you so much information that you're going to be able to work with it. Not only are you going to literally be able to tell the most compelling story about your case, but it's going to affect your case strategy. You're going to likely have far more information to work with, and you're also going to get plenty of background case facts. Now, background case facts, that's another subject that we talk about a lot on this podcast. Background case facts, they don't necessarily point to the law, but it's still extremely valuable information to have. And those background case facts, they're not going to generally end up in a courtroom. They're not going to end up in front of a judge. Opposing counsel is not going to see those background facts. Those are for you and your client to know. A lot of times they can involve the idea of what your client wants to spend the money on that they receive should they win this case. There's motivations behind what people are doing generally, and these kinds of motivations are just pieces of information that don't really apply to the law. Those are going to be your background cases, and they help you understand the deeper motivations of why your client's pursuing their legal objectives in the first place. And so for you as the attorney, those are really important because they're going to help you in cementing a bonded relationship between you and your client. So I hope that's helpful. I hope it's useful and interesting information in answering the question of why go 3 levels down. Why go 3 levels down when it comes to gathering case facts? My name is Scott Benton. I'm the host of the Classroom to Courtroom podcast. Thank you so much for listening to this episode. And if you like this material and you want to receive an alert every time we put out a new episode, you can go to our website. Our website is classroom2courtroom.com. You can put in your contact information. We'll send you an alert whenever we put together a new one of these episodes. And if you do like this material, don't forget to share and subscribe. It'll help you stay on top of all of our newest episodes. And until next time, we hope you'll join us in making the world a better place, one client at a time. Thank you so much.
Thanks for joining us on Classroom 2 Courtroom, the podcast designed to help launch your first-time legal career. If you have any feedback or ideas for episodes you'd like to hear, you can always find us at classroom2courtroom.com, where you can leave comments, ask questions, and even join our online community. And always remember, by becoming an excellent and confident practicing attorney, you actually make the world a better place. Now get out there and master the art of practicing law.